Hello viewers, this is Advocate Aashi Pawar. The topic which we are going to discuss today is understanding the NRI rights and opportunities regarding ancestral properties in India. So non-resident Indians have always had a special connection to their ancestral properties in India. These properties hold a sentimental value and have the potential for investment and future planning. However, navigating the legal and regulatory landscape governing the ancestral property rights can be a complex process for NRIs. Understanding these rights and opportunities is crucial for NRIs who wish to manage or invest their ancestral properties in India. In this video, I will talk about the rights and legal framework for NRIs regarding ancestral properties in India, highlighting the key considerations and opportunities available to them. Ancestral property, also known as inherited property, refers to the property that is passed down through generations. In India, ancestral property is governed by various personal and property laws, including the Hindu Succession Act 1956, which applies to Hindus, Jains, Sikhs and Buddhists. The Act defines ancestral property as any property that is inherited from three generations of male lineage. So what are the rights of NRIs regarding the ancestral property? NRIs have specific rights and opportunities concerning ancestral properties in India. NRIs have similar claims over their ancestral properties as that of the residents of India. If NRI is unable to come to India, so by issuing the power of attorney in the name of a local trusted person, he can claim his share in his ancestral property. It's important to note that these rights may vary based on the specific circumstances, such as the type of property, the manner of acquisition, and the applicable laws. Here are some key rights and opportunities for NRIs in relation to the ancestral property. The first is inheritance rights. NRIs are entitled to inherit the ancestral property based on the laws governing their specific religion. For example, under the Hindu Succession Act, daughters have equal rights as sons in ancestral property. NRIs, whether male or female, have the legal right to inherit ancestral property subject to the rules of interstate succession and any valid will or testamentary documents. When someone passes away without leaving a will or other testament naming all of their legal heirs, such belongings are divided in accordance with the inheritance rules. In order to claim the property in this situation, an action for declaration is filed in the relevant jurisdictional court. In accordance with inheritance laws, a successor must present title documents to demonstrate ownership of the property over the preceding 4 generations in order to establish their claim to the property in question. Testamentary succession is the process by which an individual leaves a written will outlining his or her property assets, specifically designating how those assets will be divided among heirs upon death. Property can be transferred in the successor's names by the relevant revenue department of that jurisdiction if the original will, original death certificate, and any other relevant papers are shown to the relevant department. Second is ownership and transfer. So NRIs have the right to own, manage, and transfer ancestral properties in India. They can hold ancestral property as joint owners or sole owners, as they can also transfer the property through sale, gift, or testamentary dispositions such as a will. However, the transfer of ancestral property by NRIs is subject to compliance with the relevant laws, including the Foreign Exchange Management Act FEMA regulations. Third is investment opportunities. Ancestral properties in India offer NRIs investment opportunities. They can leverage their ancestral properties for rental income, property development, or resale, thereby tapping into the potential of the Indian real estate market. NRIs can also explore the options of repatriating the income earned from ancestral properties abroad, subject to FEMA guidelines. As a co-partner, an NRI has the following rights. So the first right is to claim the share in the ownership and enjoyment of the ancestral property. Second right is to request and maintain the property related documents. Third is ability to reject kartas or any other co-occupiers alienation of the property. Fourth is to seek partition of the joint property. Fifth is ability to transfer to the other co-owners his ownership stake in the property. While NRIs have rights and opportunities regarding ancestral properties in India, they must navigate certain legal and regulatory considerations to ensure compliance and seamless management of their properties. These considerations include tax implications, repatriation of funds, updating the property-related documents, etc. NRIs must consider the tax implications of owning and managing ancestral properties in India. Income tax, capital gains tax, and property taxes are factors that can impact their financial planning and obligations. NRIs should be aware of the FEMA regulations governing the repatriation of funds from the sale or rental income of the ancestral properties in India. The regulations outline the conditions and limits for repatriating funds abroad, and compliance is essential to avoid any legal complications. NRIs should ensure that all legal documentation related to ancestral properties such as titles, deeds, fards, jamabandis, khata certificates is updated and in compliance with the applicable laws. Once you acquire your right in the ancestral property, it is crucial to protect your rights in your absence from India. For that purpose, NRIs should ensure that their properties are free from illegal encroachments and claims from third parties. Ancestral properties hold emotional and symbolic values for NRIs, representing their family legacy and heritage. NRIs can incorporate ancestral properties into their long-term financial and estate planning to preserve the legacy for future generations and ensure that the properties continue to benefit their families. In conclusion, the opportunities for NRIs regarding ancestral properties in India are vast, but they require careful consideration and strategic planning to unlock their full potential. The property may only be claimed by co-parcenary members of the 4 generations of a Hindu joint family who inherited it. The claimant's ancestors must have left the property to them as well. It can be acquired by filing a claim in civil court, verbally agreeing with the other co-owners, or by an informal family settlement. Once the shares are determined, it would be preferable to execute a partition deed. If the other co-owners are unwilling, one may file a civil case for division. A partial partition is an additional alternate whereby the claimant just obtains his portion as separate property where the remaining co-owners continue to be partners. With their right approach and professional guidance, NRIs can effectively manage, invest in, and benefit from their ancestral properties, bridging the connection between their heritage and their aspirations for the future. Thank you for watching this video, and I hope that I was able to give you clarity on rights of NRIs on ancestral properties. If you like this video, please like, share and comment and subscribe to our YouTube channel. Further, if you have any query, then write us at query@nrilegalservices.com. Thank you.